Hello everyone, I'm Nick Hobden, Head of the Employment Law Department at Thompson and Passmore, and I'm joined today by Ashley Matthews, Senior Associate in the team, and we are here today to talk about whistleblowing and what it means when an employee whistleblows and what employers should do. So Ashley, I want to firstly ask you, why does whistleblowing present particular risks for employers?
So whistleblowing can be particularly risky for employers because of the protections in place and because of the potential consequences. So if you were to dismiss someone because of a whistleblowing disclosure, then that could give rise to an automatically unfair dismissal claim. And if you were to subject a worker to detrimental treatment because of a whistleblowing disclosure, then that could give rise to a whistleblowing detriment claim. The compensation for these types of claims is uncapped, so can result in significant financial loss, and in detriment claims there can also be injury to feelings awards made. So it can be extremely costly if you fall foul of the protections that are in place.
So Ashley, what actually counts as a protected whistleblowing disclosure?
So a protected disclosure is a disclosure of information that in the individual's reasonable belief is in the public interest, and also tends to show one or more of the statutory categories of wrongdoing. So this would include things such as criminal offence, a breach of legal obligation, miscarriage of justice, danger to health and safety, more recently sexual harassment, environmental damage, and deliberate concealment of any of those matters. So the disclosure should also be raised through the appropriate channels, which normally in an employment context following the internal process, and certain disclosures to third parties in more limited situations can also be covered.
So Ashley, let's talk about the whistleblower. Who qualifies for whistleblowing protections?
So for automatic unfair dismissal claims, you have employees that are covered. For detriment claims, you have employees, but you also have workers that are protected. And the definition for worker is actually an extended definition, so it can is broader than in certain other employment law contexts, and can include things such as agency workers and certain self-employed NHS practitioners, for example. There is no minimum qualifying service requirement, so people have these protections effectively from day one, whether you're senior, junior, been there 2 years or 1 day.
So can I ask you, Ashley, how do employers go about differentiating or distinguishing between an employee grievance and a whistleblowing disclosure?
So a grievance relates to a personal workplace issue that an individual has. A whistleblowing disclosure would involve wrongdoing that's in the public interest. Now, in reality, there can be an overlap.
Yes.
In certain situations. It's important that not every grievance will be a whistleblowing disclosure, but it's important that employers are ready to recognise when potentially there is conduct complained of that can fall within that protection, so that they can escalate that up their whistleblowing policy accordingly.
So now, Ashley, I want to ask you about what are the common pitfalls that employers fall into when faced with protected whistleblowing disclosures?
So I think one of the main ones is not, as we've kind of mentioned already, is not recognising it. Where it's said more, the disclosure's made more informally or as a broader grievance, that there can be an issue with employers kind of identifying it and dealing with it in accordance with their whistleblowing policy. I think as well there could be a situation where rather than escalating it through, recognising it as a whistleblowing disclosure and escalating it through their appropriate channels, they will hear the information and say, well, that's not true, dismiss, particularly if they don't necessarily trust that individual or don't have a good relationship, that these things can kind of be dismissed and not dealt with in accordance with the policies. So that's also another risk that we see. And further to that, also where people have personal feelings about those individuals and so cannot take those disclosures of information seriously. There's also a real risk in relation to where there's performance conduct or other internal processes that are being managed at the same time. And in those cases, employers will really want to make sure that there are clear, documented, the process is documented, the meetings are documented, the decision making is documented. Should down the line there be any sort of question as to how genuine or legitimate those processes were, if that there's also protected disclosures going on, and keeping decision makers separate to ensure that the decision makers on those processes are not being influenced by the protected disclosures that have been made.
Anonymous disclosures. How should employers handle anonymous disclosures where the individual doesn't want to be named?
So with anonymous disclosures, they still need to be taken seriously, and you still need to follow your policies and the normal processes. So you would need to assess the information, investigate, and keep clear records of that process having been undertaken. So of course it's going to be more difficult, but you still need to handle it sensitively and seriously.
And so finally, Ashley, what practical steps should employers take to reduce the risk of comeback in relation to any whistleblowing disclosures?
So having a clear and robust whistleblowing policy in place that has more than one reporting route, including a route outside of the normal management chain. Also ensuring that their HR personnel and managers are also trained, not only so that they know the process to follow,
yes,
but that they can also recognise a protected disclosure,
indeed,
know the protections that are in place, and thirdly, investigate promptly and proportionately when a disclosure is made, making sure that they keep clear records and keeping the individual involved as necessary throughout the process.
So I hope you found this video helpful on learning more about what are protected disclosures, what are whistleblowing disclosures, when to recognise them, what to do about them, and how you can reduce the risk as an employer in relation to any comeback as a result of whistleblowing disclosures. I'm very grateful to Ashley Matthews for answering those questions. If you need any further information, please do reach out via our website www.ts-p.co.uk.